Good morning, everybody, and welcome to the fifth installment of our Newcomer Financial Literacy series. Today, we're going to speak to you about how to protect the wealth that you've grown over the years, either in Canada or before you came to Canada. Ensure that your gifts and estate planning is done in accordance with your wishes, and just make sure anything that you do with your funds is safe and is the way you want it done. So today we have with you Ramachandran, managing lawyer at Ramachandran Law Professional Corp. He's going to speak to us on all things legal and estate planning. So welcome, Vithu.
Welcome, Pat. And thank you to, just quickly, thank you to the Canadian ETF Association
Thank you
for putting this together. And it's a great series.
It's certainly been good so far. And this, I will be asking questions. I certainly don't have any of the answers, so I'm glad you're here. So let's start. And so maybe we'll even start before somebody arrives in Canada. Are there things that people should do when they've made the decision to come to Canada, even before they come? Is there something that they can set up and start prior to coming here?
Yes, there's actually quite a lot of things that people should be doing prior to migrating. And usually it depends on the reasons for migrating. For this example, I'm going to assume you're not a refugee or asylum seeker. You're coming in any other course. And the number one thing that we instruct our clients through, we provide immigration services, is to plan, research. And it's very, very key because there's a lot of information. If you look at all these Facebook groups or all these things where, migrants usually go to get data and to see what's out there, there's a lot of promises and great hope that's being given to some of these individuals who come. But what we tell you is that you must plan, you must research, you must communicate with people who have traveled the same path. And if you don't, we will make introductions for that. And to understand what is reality here compared to the dream of here. So, that will be, talking to people who are going to be doing the same job or coming from the same educational background as you, or same financial background as you, or going to live in the same city that you want to be living. So you have to communicate because you have to have a realistic expectation of how life is, cost of living, adjustments, and the first Canadian winter. Like if you land here in the middle of January, and you're coming from a tropical area, good luck. You're in for a shock. I was a refugee. I came in December of 1992, and I was 4 or 5 when I came, so I don't have any memory. But my parents are like, this was a shocker for them. Like they were basically like as a self-imposed house arrest, so they could survive. So it's a big change. And so we say plan, research, communicate.
Okay. So before getting into maybe some of the specifics that people can follow, in past webinars, we've spoken about Canadian markets and how it's regulated and organized, and some of the issues that have seen. So what are some of the issues that you've seen that have had negative impact on your clients that could be avoided given the information you're about to offer?
Okay, so I think one is people not getting the right type of information or from the right sources. And I think that goes back to why this series is so important, is because you get good quality expert knowledge on the topics, not a family friend telling you how to invest in stocks or how to, invest in the real estate market or what kind of RESP or RSP to go into, talking to professionals. And when they don't, we usually will get, we see the end of it when it goes south or when it goes negatively. So what we tell people is, the regulations and the organization is there for a purpose, and the purpose is to safeguard the consumer. You might not like it. You might think it's very burdensome. There's so much for you to do, and try to take shortcuts. But there's a reason why this was all created over decades of time. So what we tell people is you have to make sure you get proper advice from the proper individuals. So make sure you check the credibility of the individual who's giving you the advice. Check their research knowledge base of the person who's giving you that advice. And cross-check what they're saying with other professionals, so you get a sample of the knowledge, and then go to someone that you would, based on your research, trust. Do not go to someone just because your friends and family just referred to them, or that they're the cheapest price. Especially as a newcomer, money is very, very tight. I get that. At the same time, you get what you pay for in Canada. So, if you're getting something that is 50 cents on the dollar of what the average rate is in the market, there is a reason why it's 50 cents on the dollar. So, be very aware. Do not shop solely on price. I think price is very, very important. I mean, it's a very sensitive matter for newcomers. At the same time, it's not the only thing that you should be focusing on. Quality, reputation, trust, ethics, especially in financial management, and we'll get to that later, is very key.
Right. So we'll start at the very beginning then. You have some money, you have potentially a house or other investments. What is a will? So why is a will necessary?
Okay, so a will is the document of, I tell my clients to think of it like this. Think of it that once you die, your spirit comes out and your family's at the funeral and you're telling the family, this is what my wishes are. That's exactly what a will is. A will is a document that states your wishes post-death, and the will only kicks in after death. We'll talk about other documents later which deal with pre-death, but a will only kicks in post-death, and it's your wishes that you want your family to execute, or the trustee to execute on behalf of you.
Perfect. Okay. So everybody needs to have a will. I know there's will kits in bookstores and online. Are they valid, or should you really go to a lawyer to get it completed?
Okay, so validity depends on the process you take. It is not who makes it. So there's insurance companies doing wills, lawyers do wills, or you could do DIY will kits. They're valid as long as it meets some requirements. The person who's creating is over 18 years old. There has to be 2 witnesses. The witnesses cannot be any beneficiaries or listed parties on the will, and you must have sound mind. So basically, you're not medically diagnosed as not capable of having capacity. So as long as you do that, you can do it. The problems become, and why we recommend either you go to a professional to do this, is because a will, you could state what your wishes are, and that's the easy part. But there's consequences of every action that you must understand. So you might say, hey, I want this X to go to my daughter, this to go to my son, my wife should get this. But there's laws and systems behind this which may limit your ability to do that, or that might restrict, or may even invalidate based on what you've done, what your true intent is. So when we go into the estate planning and the will side, we're telling you, this is what everything you worked for, right? We work so hard in our lives, and you newcomers are coming to this country with the promise of giving yourself and your future generations a better life. So the entire process of estate planning is to make sure that you don't die in vain. There's so many people that come, or once they're deceased, their family comes, and it's a hot mess. And we really want to avoid that. So what we do is say, hey, we want to make sure that your wishes are honored. It's done in a legal manner. And we'll get to this later. The most thing, it's done in the most tax efficient way. Dying in Canada is not free. It's quite expensive, even on death. So you have to make sure you mitigate those factors. So, you might save $100 or $200 or $300 by, doing your DIY will kit, but it might, I've seen it cost hundreds of thousands of dollars on the tax consequences, which could have been negated by doing it properly and spending a few $100 at the beginning. Remember, this is everything you work for. So don't take a shortcut on this.
Very good advice. So in past webinars, we've talked about saving for your children's education using RESPs, retirement using RSPs, and saving plans for homes. When it comes to supporting your children and other family members financially, how should this be done safely and in accordance with your wishes?
Okay, so when we sit down with the client, when we do estate planning, we don't just do a will. Like we say, I want you to go back, we would have an intro conversation and say, what is it that you want to leave behind? What's your legacy? Both financially and otherwise. And we have to cater everything towards it, because the goal is when you die, you have to die with your family not fighting. I think it's one, with you protecting your financial assets, number two, and mitigating taxes, number three. So happiness is key. So for that, it's not just the will and estate portion that deals with this. You actually have to set up a lot of things in your life. So when you come back down to the estate side of the on death side, it's done properly in a proper manner. For example, one of the things that we newcomers, that even my family did, is, for as newcomers, especially if you're coming from the Asia, South Asia side of things, or the Middle East, buying a property, like historically, we've been advised that gold and land are the two things that are the most valuable asset classes. So for people of my descent, especially, they would value buying a house, as most newcomers, and giving financial stability to their family as the number one priority of the first real asset that they have. They may have RRSP accounts and TFSAs, but the goal of those is not for savings first, is to buy a house, buy a home to live in. We're not talking about rental property, but buying a primary home. So when we do that, especially as newcomers, we may not have the credit, we may not have the income requirements, we may not have other factors that the bank considers to give us a mortgage. So what we would do normally is we will have a family member, an extended family member, or a guarantor come on the deal and come on to title with the property, so we can make the numbers work. Or we will get into what is very common, is having multiple nuclear families co-join to buy an asset, and they will split the living accommodation. So what happens here is, when we take title to the property, there's consequences of the ways we take title when it comes to estate, or even for taxes. So, if you give someone 1% ownership, even, they're a legal 1% owner. But for example, you might just have them on there for mortgage purposes. So what we say is that, hey, if you're having them on for mortgage purposes only, and they're really not an owner, you need to do what we call a trust agreement between that 1% owner, or that person who's coming on, who's not financing the deal, who's not living there, who's not going to pay the property tax and utilities, and you. Because what happens is that person then can dictate what happens to your home, even though there's such a little portion of the total value. So trust agreements, for example, say that, hey, even though you're on title with me, I'm the real owner. You're only here for X reason. You're not getting anything out of it. Therefore, so even if there's an issue later down, or if you pass away, we all know who the rightful owners are, so we could distribute those assets. You don't want your biggest asset, which is usually your home, and biggest tax-free asset, which is usually your primary home, to be split up like this, or to be tied up into litigation, which is what you don't want at all. So we say, hey, do this. Another issue that for an estate planning component is that, you could take title as either like partners, what we call tenants in common, or joint tenants. In this presentation, we're not going to go into too much of the technical aspects. It's a bit more high level. But for example, joint tenants means, like, say, me and Pat co-buy a home, and we take it as joint tenants. That means if something happens to me, Pat gets all of it, tax-free, my entire share. But when Pat, eventually passes away, which I never hope to happen, then she'll have to bear the taxes from the time when we started buying it, and including my share. So that's great between spouses. That's great between elderly parents and children. So you could avoid some of the taxes. And remember, these are, when we're talking about, hundreds of thousands of dollars of equity, we're talking about multiple types of taxes. We have estate taxes, what we call estate administration tax, which is roughly about 2% of your net worth. You have land transfer tax if you want to transfer it to someone else. You have capital gains if it was an investment property. And income taxes for the death person on death. So you have at least 4 taxes to compete with on every single asset. So, those are very, very key things that we plan. So even though if you come to do a will, we'll be like, hey, why does a husband and wife have ownership like this? Let's change it. It might cost you a couple $100 to do, but I'll save you thousands of dollars, maybe tens of thousands of dollars when you do the estate planning. That's one. People have businesses. They get into business with friends and family or strangers. You need to have shareholder agreements. Because if something happens to you, how is your family going to know and have a record of who owns what? And this is very key when we do it. A lot of newcomers, they say they may not have the funds for it, or we'll do it later. At the starting of a business is very hard financially. I get that. But these are considerations that must be taken into place, and the cost of opening a business to protect yourself in the long run. You have to have proper accounting. There's so many families that come in here and they say, oh, this person passed away and they had all financial control or did most of the financial management for the family, and we have no idea. So, we have to make sure accounts are set up. There's some joint accounts, there's some enough money so they can at least pay for the funeral, that there's money split, to open probate, pay for all the other expenses prior to you to getting access to an account. For example, the worst case that happened to us is, the person with primary financial control of the family passed away. The wife and kids had nominal amounts of money. Everything was locked up into this person's account. It wasn't a joint account. Now, for you to go through the probate process and get access to that person's account, it could take you if you're in Toronto, the GTA, anywhere between 6 months to a year. So how are you funding yourself for 6 months to a year when you just lost your biggest pillar in your family? So we make sure you educate people on this and make sure how you plan your financials on a day-to-day manner. You might come to us for a will, but we'll say, hey, you might have to change this up or make it a joint account to give you the security. Clean records. I see this in the newcomer area as well. We do a lot of cash transactions, and the problem with cash, it's not tracked, and what's not tracked can't be recovered. So if you start giving up promissory notes or cash, loans, or receiving interest in cash on loans, if you don't track of it and there's no paper record, then you can't collect. So or it becomes a very costly exercise to collect. So we talk about this. We talk about setting up your finances. These are other tools for wealth management. You got to set up your family, the finances in the family. For example, are you separating? Are there going to be child support obligations, spousal support obligations? Do you have children with accessibility issues? There's special estate trusts and wills that can be made so they may get assets but still be able to receive the government subsidies, especially with kids with autism. Like, there's special provisions for them. So that's why professionals are necessary. Are you giving a living gift to a child? A lot of parents now are giving the down payment for the children's houses, and they're saying, hey, this is your gift while I'm alive. I'm not giving you anything on death. It's going to go to your other siblings, but you've gotten it. But how are you going to reconcile that? Because once you see the will, it says, oh, one child is excluded. So you need to make sure there's notations of it. There's reasons why it, an inheritance to kids. We get this asked a lot from us by everyone. It's like, hey, if I die and it goes to my kids, but they get married and then there's something happens in their marriage, does he or she, the new person that's come in, take it and go? So how do you protect that? So there's specific inheritance rules and laws. So like we make sure when we sit with you, it's not just about the estate and wills. And I think this is the difference between like DIY stuff, where you may think that you know everything, compared to like talking to someone who's going to sit down and have this conversation with you. Financial planning is key. Like that's for another webinar, I think, with the team later. But having the proper financial tools, they could be RSP rollovers, TFSA rollovers, and there's tax advantages to that. Insurance planning. When we sit down with you and do estate planning, we say, hey, we need to talk to you. You might need an insurance agent. You might need stuff, because who's paying for the taxes? Do you have $300,000 of cash sitting around to pay for taxes? Or are you forced to sell the house that you wanted to give to your spouse or to your children because you don't have money for taxes, so you have to liquidate the asset? So those are all other considerations. And lastly, we're getting into estate planning. Then we actually start doing the actual thing that you came to us for, which is part of doing the will, doing the power of attorney, the living will, etc.
Sorry. I just want to go back on one of the things you spoke about, which is wanting to give to your children, and maybe they haven't gotten married and then they do get married. Is there anything that you are able to do to restrict in case that marriage isn't successful and
Yes,
breaks down?
yes. So there's two parts to it. So the first part is you're giving him a gift, and you're usually going to, on mortgage purposes, declare it as a gift. So you have this thing that you're saying you're giving away with no consideration. At the same time, you say, hey, if something does break down from the family, like which you don't want for your child, you and your child need to be protected financially. So you have these two competing ideas. So what we do is, like, one of the things that we recommend is like, okay, a lot of parents are getting into this right now with giving the gift. He's saying, okay, we're gonna note this on the estate planning side, but between the couple, we get a lot of parents are actually signing a second mortgage against the house that the kids are gonna buy, but at 0% interest. So there's no interest payment. And every 3 years, if they as long as it's ready, they just renew it perpetually. But if the marriage breaks down, the parents get paid out the principal. And then the parent could re-give it to the child, but that's one of the safer ways of doing it right now. Because if you just say, oh, I gave it to my child, but then you have this mortgage document that says there's a gift, then it becomes a marital gift, which is split in half. You don't want that. Because even though for mortgage purposes, you might say, hey, it's a gift to my kids, you don't want that. Or what you have to do is inheritance kicks in when a person's dead. So while you're living, if you give a gift, it's going to be split. This is the more safer way with respect to real estate. Now, if you give it to something else, where they don't buy a real estate and they don't give, there's really no security you're going to get in case that marriage breaks down. So you have to be careful why you're giving it, what you're doing. Like, are you paying for the wedding? And if you are, like, is there going to be a promissory note for it? It could be at 0% interest, but a note with a 3-year term. Hey, I'm paying $40,000 on behalf of the wedding. When you guys are in a better position, either pay me back. And it, because you could have it all documented and signed, you don't have to exercise it as a parent. You could, at the same day, if everything happily ever after, just rip it up and go, because you are the one in charge. But that's what we want. We want to give the person giving the money the control and the ability to safeguard their asset. And it's key. Like, we have a lot of young people coming in here for prenups, marriage contracts, because there is assets. Because how many, for me, I'm on title with my parent for their house. So, but I'm also married. I have my own family. So if something happens to me and my spouse, then it's going to affect my parents' home because I had to go on title. So we have to have agreements and stuff to outline whose is what and what happens at the worst case scenario.
And does the same thing hold true for things like dowries or gifts like that? You just want to make sure that there's something in place?
Yeah, and dowries are treated very differently depending on which part of the world it's coming from. For example, if you're coming in from the Middle Eastern component, the women usually get, I'm not an expert on this, but it's called, I believe it's mahar or maher. It is basically, the man provides as a security for the woman in case he does leave and is due if, like, the marriage breaks down. So actually Canadian courts have treated that as a valid outstanding debt. But what usually doesn't happen is there's no recording or there's no document that outlines the terms of this agreement. So in certain cases, like especially in that case, it has been held valid. In other cases, like if it was a forced dowry situation, or if it was already given with no context to it, then it might just be treated 50-50. But depending on like how it's classified and what the consideration is, it may be valid. So if it is, we need to record it. How are we going to document it? How are we going to protect you in the event something does happen?
Great, thank you. And in one of your answers, you mentioned the term living will. Maybe
Yes.
you could just go through and explain what that is.
Okay, so living will in Ontario, so living will just says, hey, while I'm living, these are the things that you could do for me. But the problem is with the living will, it's very toothless. So it's almost the starting point for a power of attorney. So at that point, we just say, do a power of attorney, do not do a living will. It confuses people. It has two documents competing with each other, especially if they're differently outlined. We say you do a will, which deals with you post-death, and a power of attorney. For power of attorney, there's two types of it. One for property, they call it for property, but it's for anything that is not related to health. And the second one is for healthcare. So in your health power of attorney, you could do, so let me backtrack. A power of attorney, the attorney is a person that you give control to make decisions on your behalf. That timing could be whenever you sign the document or when a certain event happens. For example, if you become, if you lose capacity, Alzheimer's, certain things happen at a certain age, or at a certain age, then you could have that, hey, if two doctors say that I'm medically incapable of making decisions, then this document kicks in and this person's responsible for dealing with my affairs. So that's very key. And it was really scary with COVID that, you know, people who were 35 and 36 and 40 didn't have a power of attorney and their families got screwed because everything was tied up in their bank account and mortgages were going from their account. They didn't have money. They can't access the account and mortgages were bouncing. Banks were calling up and saying, hey, what's going on? So you might think it's, hey, when I'm getting older in age, I need to think about these things. But given what's going on in the world right now, I think everyone as part, if you have a family, you have a duty to protect them. I think that's my simple philosophy, regardless of how much money you have. You need to have the basics in place, a basic will and a basic power of attorney. So on the property power of attorney, you can have everything outlined for your access to bank accounts, safety deposit boxes, assets, who gets to control it, and who gets to make decisions for you while you're alive. On the healthcare, on the health power of attorney, you could make decisions on, they don't have to be the same person. The attorney does not have to be the same, it can, but they get to make a decision on, you know, where are you, what is the health decisions going to be made for you? That includes, you know, what kind of senior home, what kind of healthcare, dressing, eating, dietary restrictions, medication. But one of the best things that you could do with it is also make advanced directives. In that sense, end of life decisions. So you could give that to someone, or you could say, hey, my power of attorney for healthcare allows you to do this, except for end of healthcare decisions. And you could set your own terms. You could say that, hey, if I'm on life support for 30 days, pull me. Or, you know, I want to be perpetual living as long as I medically can, or if I'm brain dead, you could set whatever the terms are. And we suggest you make the decision rather than someone else, because that person now has to explain it to the other living members. And, you know, not everyone will be, maybe not be on the same page. And then it will create animosity and resentment. And we do these things so we take that away so your family can live happily ever after, not to create new problems for them.
So just a clarification then, if you have a financial power of attorney, can you put in rules around when that would be, when you would kick it in, like when it would be enacted?
Yes. So for either power of attorney, you set the terms of when it starts, how it starts, and even how it ends, maybe.
Great, thank you. So maybe walk us through what will happen if you die without a will.
Okay. So if you die without a will, so if you die with the will, you have a separate type of law that kicks in, and if you die without a will, you have separate types of law that kicks in. But what everyone needs to understand is the money does not go to the government. It's not like in other areas of the world where the monies go to the government. You do not have to worry about that going to the government. But your ability to control from the grave is very limited, because there is a set stone of things that will happen. First, it goes to your spouse. All of it, if that person's still alive. And
if you don't have a will.
If you don't
Right.
have a will.
Okay.
Yeah, this is just if you don't have a will.
Yep.
And then if they're not in the picture, it gets split equally between children. And if you don't have children or a spouse, it goes back on grandchildren or great-grandchildren. It goes back up the family tree to your parents. Then if you don't have, if your parents are not in the picture, then it goes to your siblings equally. But you don't get to pick how much and when. Also, you don't get to set and account for the tax consequences. So your tax consequences usually are going to be at maximum because you have a tax plan. So it becomes more costly for individuals who are to die. Now, here's the thing with the will. You may think, oh, I could control everything from the will, but the law says there's one wrinkle. It's because in family law, if it's a family law, I guess, issue is a lot of people might say that, hey, I don't want to give anything to my spouse. They may remarry, they may do something with my money or, whatever, and cut them out completely and say, hey, it goes to my kids directly, split, but your spouse is still living. Even if you do that in a will, the courts have said, no. You cannot do that. As of March 1st of this year, there's something called the spousal election. So what that says that regardless of the size of your estate, your spouse has the right to claim the first $350,000 of assets after paying expenses, funeral debts, and taxes directly to the spouse. And everything else gets split. So for example, in my let's say in this example, there's a husband, wife, and 3 children. So the husband says in his will, nothing to my wife, all to my 3 children. And then the 3 children will be like, great, we're getting 1/3. What will really happen is you pay off all the debts, all the expenses, all the taxes, whatever is left. If there is more than 350,000, if there's less than 350,000, the wife gets everything, regardless of what the wish was. And if there's more than 350,000, the first 350 goes to the spouse. Whatever is left gets split by the amount of kids plus the spouse. So the remainder also gets split by the spouse plus kids. So now whatever's remaining gets split by 4 in my example because there's 3 kids. If there's 2 kids, it'll get split by 3. If there's 4 kids, it'll get split by 5. So even when that's why I say you could do your DIY will and say, hey, everything's my kids, but it won't be worth the paper it's written on.
Okay. So in that circumstance, hang on, I'm trying to get it clear in my head now. I think I'm gonna have to redo my will. Would they have to sell the assets to be able to do that? I mean, that's the other risk, right? If the assets are home,
Pledged.
yeah, they may have to sell whatever they've got.
Okay, so this is where our insurance planning is very, very important, because once we do your estate planning, we will estimate what your tax hit is as of today if you were to die. We will make certain assumptions on what the market's going to do with you and your financial planner and your insurance planner, and say what's going to be in 5 years, 10 years, 15 years. And make sure, if your goal is to give, let's say you have 2 houses, one is investment, but one is for your family to live in, or you have 2 children, one is going to go for each one. Well, it's your responsibility to make sure the mortgages are paid off when you die. And you could do that. So even if you die with a $500,000 mortgage, that's okay. As long as you have, for example, like mortgage insurance, or better yet, term insurance to cover whatever the debts are going to be. And, we say, get someone you like, your spouse or someone who's really close to you, to be the beneficiary of those proceeds, so tax-free, because if it comes into the state taxable, tax-free, that person uses those funds to pay off those mortgages. Now your kid, so after it goes to probate, so your tax hit is less, and then you could keep the asset class. And you're going to need money for taxes. You're going to need money for capital gains and everything. So we have to make that accounting and say, hey, we're not an insurance expert, but we need your insurance expert at the table with us during our second, third, or fourth consultation, so we can plan accordingly. Because we'll defer the financial part to the financial planner, the insurance part to the insurance planner, and we need your accountant on board with us. So we could get the professionals to give advice. Like, no lawyer across the board, Sean lawyers, will be able to, or in the best position to give you insurance advice, financial advice, tax advice, and legal advice. No. So, this is why we have people with licenses and stuff. So you have to make sure, like, what we do is, if you want to give the house to someone, we have to make sure your debts are paid off. How are we going to make the debts pay off? We need to have a financial plan for it. So that could be either a TFSA, RRSP,
And so,
insurance,
and
something.
to that end, because we have a question coming in, but I just want to wrap this up. if you needed insurance to pay off the mortgage, it wouldn't necessarily have to be the parents that has the insurance or paying the term. The children could be paying for that insurance policy, correct?
Yes. I tell parents, I'm like, do not overburden yourself more than what you can financially. This is a family conversation. Saying this is what we have. This is gonna go to my wife first, and then if she's gone before me, then I want my children to have it. But this is also my financial, say, condition at this point. I can't take on another $100 payment. But you guys are going to be inheriting something that is worth probably $1 million for less than $50,000 or $100,000. So you're going to need to have skin in the game. And the policy, and since they're younger, their coverage is like if they put it on your parents, maybe a couple $100, but they can think of it as a retirement fund for them or a part of their investment fund, because everyone's going to die. And normally when you're older, you're going to die quicker. So if that's the case, then no child wants to bet on their parents' death, I would assume. But at the same time, you could plan for the inevitable and at least come out financially better in that situation. So I think that is a very good strategy. And without having the parent, what's in it for the parents?
Yeah.
Like they've done so much as much as they can. Why burden them more?
Yeah. Okay. The question that's come in is, if the deceased did not have a will and doesn't have children and only a surviving spouse, do you still need to go through the legal process to transfer the assets to the spouse's name? And if so, what would be the process? And especially if the asset total is not, say, maybe below 50,000 or below 100,000.
Okay, so this is where we get into those different tools that we could really use to help offset the estate taxes component. For example, if the property, if you're talking about a property which has, let's say, equity under 50,000, and you were both joint tenants, you don't have to do anything. Your spouse will just have to do a spousal transfer, a transmission on death, and that will be less than $500, and you're done. No land transfer tax, no capital gain. You don't have to go through the estate process. Nothing. You'll be done in hour and a half. Done. If it's money, let's say in a bank account or a savings account, also, if those accounts were joint accounts, if they pass away, you don't have to do anything. It automatically rolls over to you. If it wasn't a TFSA or a RSP that has a rollover, like a beneficial designation filed, and it's for the spouse, you don't have to do anything through the estates or will side. Now, if it's in a solo account or it's in a house where the spouse is not on title or your tenants in common on title, then you have to go through the estate process. Now, if it's below 50,000, well, we have something called a small estate. So you could do an application for becoming an estate trustee of a small estate. It's declared, I believe now it's under 75,000 or 100,000. It's because of inflation, they wrapped up these prices, these guidelines. So then you will still have to do it. It's an expedited process, but it's still going to take you about 6 to 9 months. And that process is still going to cost you anywhere between 3 to 10,000. And this is not factoring in any tax arrears, because tax arrears have to be brought up if you're going to do an estate application and transfer of assets. So there's different tools, right? Like that's why we had to set it up properly. So, this person with $50,000 may end up with 35,000 net. Had they, not had a will or did a DIY will or didn't plan properly, or they could have paid a couple $100 for their lawyer to do a will, and a couple $100 for the surviving application, and for less than they would retain almost 49,000 net. So it's like it's retaining 35,000 and not using a lawyer or professional, right? There's more to it than just a DIY kit.
So given that, can you, well, hang on, I want to backtrack a minute. So in that specific example where you just have a will, does it make sense to still have a small life insurance policy? Like, how quickly can you get the life insurance policy amount to, again, help pay for all of these other costs?
Okay, so The typical answer is about 30 days from the time you file your proof of claims form. That's been our history. And for the insurance company, they just want you to fill out a form and provide the death certificate. So usually right after the funeral, you get the death certificate at the end of the proceedings. You file it. Most insurance companies are very, very friendly and very, very thoughtful, especially if you have a broker involved. So you will get paid within, let's say, 30 days of you providing that application form, typically. However, that is as long as there's a beneficiary listed on the policy and the beneficiary is not deceased. Because if they're deceased and you don't have contingent beneficiaries or there's no one else left, it comes into the estate. And then the answer becomes 6 to 9 months because you have to apply to become an estate trustee. It takes about 6 to 9, that'll take you a couple of weeks to do the application and file it in court. Court takes 6 to 9 months to process it. And then once there's an estate trustee appointed, then you file the form and send it to the insurance company, then another 30 days. So something that could be 30, 45 days may take 10 to 12 months if it's not planned.
Can the children come up with and get an insurance policy on their parents or parent and pay for it, going without telling their parents? And I'm not thinking of being secret, but in terms of perception, you made it, you don't want it, you're not thinking about when your parents pass away, but this is just my protection in case there's costs. Is that possible to do everything without the parents knowing about it?
Actually, from personal experience, because we've actually had to sit down with my parents, no, because almost all insurance companies that I've had quotes with or experience with have stated that the insured life must sign, and especially if they're much older, they have to do a medical, so they'll be subjected to blood tests and blood pressure tests, or if it's a non-medical policy, then they have to release their medical records. They have to consent to release their medical records and answer medical questionnaire on it. So
okay.
No.
The conversation has to happen. Okay.
Yes.
A question that's come in is, if I am forced to request my insurance to pay off the mortgage, will that affect my credit score, or will it affect me negatively in any way?
So for this question, I think I'll let me break it up. Okay, so if your insurance policy, so there's two types of insurance policies that people promote for paying off mortgages, and we have to understand who the real beneficiaries are. Mortgage insurance that is promoted by the bank at the time of signing, the beneficiary is the bank. So whatever you're paying pays off the debt to the bank. And even though your balance might decrease, your debt may not decrease as much. So we say shop it around with term insurances, where the beneficiary is whoever you want it to be, for two reasons. A, they get the money and they only pay the balance off. And the second reason is, when we do your financial calculation for taxes, if there's a mortgage owing at time of death, then only the net difference is taxable. But at time of death, if the debtor is being paid out by the insurance policy and it's mortgage free, then your taxable amount has increased by the mortgage amount. So you have to be careful on the timing of these things. So be careful with that. It will not affect your credit score, but if you don't pay your mortgage with the insurance monies or other monies, then you will, if you are a co-borrower with the deceased, then it will affect your credit score. But a dead person has no credit score. So that's why most banks, most of the major 5 banks and even the other ones will give once you report that the person has passed away, they will allow you to make manual payments into that account manually at the branch or by sending in checks, or they will give you like a 6-month grace period for you to refinance and move the property over or sell the property. So financial institutions, as much as people say they're evil, they're empathetic in this sense, like from our experience, they've been fine.
So insurance payouts to a spouse are, the mortgage lender keeps an eye on that, so they know, so it goes into the estate? or it's
No,
totally
no,
separate?
no, it's totally separate. But then the
Okay,
person who receives the funds from the insurance, the term policy, can now elect to use it to pay off the mortgage once the taxes have been calculated.
okay, okay,
Uh, or they don't have to pay it, right? They could transfer the mortgage or refinance the property and just use the insurance money to maybe make the next 15 years of mortgage payment, and invest the rest of the money elsewhere, which may create the revenue for them to pay the mortgage. Like we'll have to sit down with the financial planner. We'll say, okay, where are your finances? These are our professional suggestions, and take it from there.
yeah, no, that makes a lot of sense. So when you're doing a will, um, spouse aside, can you be really specific in what you want to give? So you
Yes.
have very specific things to very individual people. So how does that get enacted? Like how do you make sure that happens?
Okay, so you could give what we call, there's two types of gifts. There's specific gifts, like you could give a specific account, jewelry, piece of artwork, pet, anything tangible, or even intangible when it comes to stocks and stuff, to a specific person. As long as there's money in the estate after paying taxes, funeral debts, legal fees, professional fees, and a tax ban, anything that's left, the specific gifts get paid out first. So we have to be careful that your intent of what you're leaving behind to everyone is captured properly, because the specific ones go out first. Then what we call the residue or residual of the balance gets split. So if you have to be careful when there's multiple people involved, if you want to give it, are they of the same value, or is it like, especially with I've had a lot of experiences in South Asian culture, they'll be like, okay, to the daughter, all my jewelry, from the mom usually, but then that could be worth $100,000. So if it is, are you giving if you have male heirs, are you giving them an increased amount on different asset classes to offset for that? So yes, specific gifts are allowed. You could even do specific other organizations not related to you. They could go to charities. They could go to any charity in the world or any organization in the world. Mind you, if you don't have the proper contact information and details associated with that, it will increase the fee, like the cost and time for the estate trustee and their partners to do that work, to find this person, to get authorization, to remit funds. So it will eat away at the residue. So, you have to do it. You can't say 2% to this person, 5% to this person if your pot of gold isn't that big.
So you use the term executor. Who is that?
All right. So executor is also referred to as the trustee or the estate trustee or the testator. So this is the person that carries out the wishes of the dead person. So who is going to be responsible for doing it? And we tell people, do not pick a senior to do this work. It is very taxing. It's very hard. It's very, you have to be cold and ruthless. So you have to find someone, as parents, we know our kids the best. We know which kid is good with money, which kid is not. We know which kid is the mediator in the family and who could bring people together. So you have to balance these interests, because they have to be good with money and they have to be a mediator who could deal with the family bullshit that comes along with it. Because when people at funerals, it's a very emotionally charged time of everyone's lives, and everyone's grieving in a different manner. And so this person has to be mature enough to understand that and to navigate through the human component to resolve the state component.
So what you've just said, would it be easier to have a non-family member act as executor then?
The problem with that, yes, you can. The problem with that is there's a cost to it now. So even if you don't say, if you name a estate trustee or a executor or testator without naming compensation within the will, the laws allow for them to get anywhere between 1% to 3%, depending on the size of the estate, as their compensation for doing the work. But when it comes to getting either a trust company to manage it, or the banks, or a professional company, well, they're going to start charging. So unless you have a fee schedule already pre-negotiated, we do not suggest putting a third party. But you have to trust in the people you leave behind that they're going to get it done.
Yeah, no, that's fair. So maybe just as, if there are any questions for people, can send them in through the Q&A box. I guess just the last question I've got listed is, maybe you can just walk us through at a high level the process and the timelines. We've spoken about bits and pieces of it, but when somebody passes away, what is the process that has to happen? And then maybe that will tell us why it's so expensive, or why it takes so long.
All right. So the process, these are for assets that are not joint, or we're using other tools that we've
Right.
talked about, and just going through the will. Right now, to do an estate application that's not contested, to do anything, probably the legal time frame is probably a week to 2 weeks to get the initial set of documents ready and sent out to court. Well, I can't blame COVID, because the courts here were already slow. They just made it even slower. So right now we're averaging between 6 to 9 months. Used to be 4 to 6 months, unless it's super urgent. For example, there is someone died in the middle of selling their home. They sold their home, it's closing. We could go to the court and get an urgent application. A lender is going to foreclose the property. We could go to the court to do it. Or if there's a fight between who's going to be the estate trustee, you're going to go. But we also have a file where unfortunately the client died in, I think, November or December of last year. There's a fight between the family of who's going to be the estate trustee, because there's a battle of wills and other documents. It's more complex. And now it's October 18th, and still they haven't even decided that. So only after that will the court sign off, and you got another 6 to 9 months. All right. So if there's no contest and you get a probate certificate within 9 months, then from there the estate trustee could start doing their work. They have to collect all the bank accounts. They have to go to every single bank, find out where they have accounts, go to every single financial institution, mortgage lender, and figure out what we're going to do with the properties. Are we going to list it? Are we going to refinance it? Who's going to take ownership of it? Talk to the accountant, catch up the dead person's account. If there's businesses, what are we doing with the shares? Like, we haven't talked about business. I'm going to come to that next. How are we wrapping it up? Is there a shareholder agreement already in place? Does the shareholder agreement talk about what happens on death? Deal with this. Is there minor children? We haven't talked about minor children. Is there minor children involved? If there is, now how did the will set up for the kids to get money? Because if there's no trust being created out of the estate, the estate has to be open until the last child turns 18.
Oh, geez. Okay.
So you see the issue that becomes, because now the estate trustees may be working for 16 years, 17 years, 15 years, depending on the age of the last child. So those are factors of it. But assuming all kids are adults, 9 months, it probably takes about 6 to 9 months again to do the accounting, final taxes, wrap up, transfer of properties. And then you have to apply to court and say, hey, here's a list of assets, here's a list of debts, this is the remaining amount of money we have. The will says this is how we want to distribute it. This is our plan for distribution. We have the consent from all the beneficiaries. Or if they're fighting, hey, do away with their consent, give me a court order to go ahead. That could be another couple of months, depending on if there's no contest. And then you get to wrap it up and dispose. So you're looking at an 18 months to 2-year process without problems, right? If there's problems, I've seen estates being open for 2 to 5 years. I've seen estates being open for a tremendously long amount of time because they do DIY and they don't factor in for the minor children. Because what we suggest for minor children is, even if we never suggest giving an 18-year-old $1 million, because the people around them or themselves will waste the money and destroy the child. Screw the money, but they'll destroy the child. So you have to be financially prudent on how are you going to set up the funds to be released for the child. Who's guarding those funds? What's the rules for guarding the funds? How can the guardian use those funds or invest those funds? And how could they attach a principal? What's a draw period? So, if you have minor children, you have a whole different ballgame that you're coming into on it. If you have children with disabilities, it's a Henson Trust. So we have to make sure we account for it and do it properly, because if it's not done properly, it breaks down. So we got to do that. Do you have businesses? Well, see, you don't have to show the government every will. You only have to show the government every will that you need to be probated. And there's nothing illegal about not showing the government a will, because the state trustee can do it themselves. So it's actually possible for you to have multiple wills. So if I do a will, let's say I did it last month and I do a will today, the one that I did today controls. And to say that, a will is also considered a beneficial designation. So if your will is not drafted properly, and you say, I revoke all previous wills, testaments, and beneficial designations, you're actually revoking your life insurance, your TFSA, your RRSP beneficial
Oh,
designations.
geez.
So you have to carve that out. So that's key. And then when you get into the will component, if I do two wills today, I could actually have multiple wills working for me at the same time. Both are valid, and both are 100% legal. And you actually want this because, for example, anything that you don't need to get probated, like for example, giving a specific gift, transferring shares of a corporation, not a public corporation, not on the stock market, but a private corporation, does not need a probate to happen. They don't need the government's approval for that, because you only need the government's approval for things like bank accounts, because or you need it for property because the land registry requires it. Because on anything you probate, you have to pay the probate tax, and everything you don't probate, you don't have to pay the probate tax. So if you're a small business owner, you can't be affording to have your business appraised and have a certified appraisal from a business valuation. That'll be like $5,000-$10,000 for a company who makes less than $100,000. So you can't be doing those things. So you need to set it up properly. Let's say you have an antique piece of furniture or art. Do you want to get that valued and pay tax on it, or do you just want to give it away to the next person? Right? So we could set it up, and you're not restricted to two. You could have three. So a lot of people do one for anything you probate, two for businesses, and the third one for antique or artwork, depending on the value. For professionals who are like accountants, engineers, lawyers, since we have professional corporations, our colleges and bodies actually mandate us to have a will, and the only beneficiary and the estate trustee has to be another licensee. So it might not even be someone in the family to do it. So there's different considerations you may have. So you could even have more than one will, right?
Do you reference the other wills in each so that it's
yes.
So you would just say all the specific gifts are in will number one. This one is only going to be tied to okay.
Yeah. So you will make notes, you'll make codicils. So you could get very complex. Like I've seen wills that are like 64 pages, 68 pages.
Is that only when there is something that will have to go through probate specifically? So you don't want to tie up everything else?
No, because the probate ones are more straightforward. It's the ones where it's not probate that you want to give more specific instructions, because you don't want to risk it to come back into a state's court because of misinterpretation. So you just have to be more clear on it. If there's minor children, remember, so a lot of people don't understand. It's like, oh, I give custody. If me and my wife die, my children's guardian or custodian is going to be my sister, for example. But if you put that in a will, it's only valid for 90 days. So after 90 days, there's no legal guardian for your kids, because the person you want to become a legal guardian has to apply to guardianship court and get a permanent court order. It's going to cost them $5,000 to $10,000 to do that. So how are you comping that person to do that? So there's a bunch of other considerations, right? Like, where's your kids going to live if both of you pass away and they're minors? Are they going to go to boarding school? Are they moving in with a guardian? Does the guardian have enough space in the car, in the house? Schooling, after school activities? How are you comping them? Because you can't, it's not fair for someone else to say, oh, you died, so you take my 3 kids and, you raise them as your own. The kids are expensive in Canada.
I'm glad my child is old enough because I didn't do any of that. Okay. That's interesting.
So like, when we meet with a lot of people and we have this initial talk, their reaction is like, basically your reaction is like, shit. And we say, hey, we'll send you some minutes and notes on what we talked about, and contact in a couple of weeks. So, because this is not something you could think of and agree on the spot, or you have to sit down with so many stakeholders, so many family members, because you're affecting lives outside of the nuclear family, especially your minor children. So you got to get consent from them. Are they okay to become your child's custodian? Maybe they don't want to, right? Maybe it's too much for them. They don't want to deal with the family dynamic that will happen, right? So it is a lot, but managing your wealth is not just determined at death. There's things that you have to do throughout your life to protect your investments, your assets, and ultimately for who it should be going to, your family. right? So, we'll help you during this journey, and we'll make sure we get your partners involved during this journey. But it's a team effort. And anyone who says no, I would avoid them.
Well, you've said things certainly that I have never heard from other lawyers or financial planners. So this, for the reminder for the people that are listening, this is being taped. So it's probably easiest then just to ship the link out to all your family members so that they're aware of this too, so that they will understand why certain things are being put in place, that it's not that you want to control the process and the assets. It's so that, one, it's safekeeping as much of the assets as you can, and so that they're distributed according to your wishes, which I think you've laid out so many areas where that potentially could not happen, given family law and things that you didn't know down. Is there a potential for a will being written and then the people that are inheriting don't agree with it and they can battle it? Like, what would win out? I mean, you've given one example of family law beats a will. Are there other examples of that?
Yeah. So people would say, especially if a person wrote a will at a later age in their life and they were already having medical issues, did the person have capacity at the time of writing it? Especially if an older will gave more to a certain family member than the newer will, or if there is a new if assets are going to a caregiver, you see a new will, you see elder abuse. It's not uncommon for a caregiver to be awarded or given in a new will everything or a lot of it or a significant portion of it. And they'll say, hey, why is this caregiver getting it? It could be that, at the end of the life, this caregiver is the one who really spent the time and value, and there's nothing wrong with that. But at the same time, it could be elder abuse.
How do you know? How would a family member know that though, right? Would you not know until the person passes away?
Yeah, because you don't have to publish your will, and there's no requirement in Ontario or Canada to publish your will. Therefore, your will only comes out when you're dead. So what are the challenges you're creating for the people you're leaving behind? We would say that, do a will, do a letter accompanying it. So the letter is not going to be probated unless there's evidence required of saying, this is my wish, this is my medical condition, this is where I'm at, this is how I'm doing today, and this is why I'm making the choice I'm making today of changing what I'm changing. And I hope you honor and trust it. But at the end of the day, if people want to challenge it, they challenge it, and lawyers would love to challenge it, because lawyers who challenge those things are usually paid on contingency. So if you're getting a 300,000 windfall and they're going to get a third of it, for them to risk 5 or 10,000 for making potentially $100,000, mathematically certain things are in play. So we see it, we'll see where it's coming from, and we're like, okay, this is why this is happening. So you got to be careful.
So a question has come in: is a holographic will equally accepted in Ontario as a regular will? So like a video, and are there downsides of doing that?
So a holographic will must still be in writing, cannot be a video.
Okay.
It has to be handwritten, or at least signed in hand. There's competing case law theory out there whether the entire will has to be handwritten and signed in wet signature, or whether it could be pre-typed and signed at the bottom. Right now, courts are more leaning towards, okay, you got to write everything, because they're like, if you could type everything, why not just get it witnessed by two people? So I would suggest, if you're gonna, yes, they are accepted. If you want to do it, you got to do it all in writing by pen, the old school way, sign it. You don't need actual witnesses for it. But it becomes harder to probate, and there's challenges that arise of it because there's no witnesses who wrote it, and you could contest whether that person was the actual author of it. You got to have handwriting experts. Potentially, it becomes a costly exercise to probate if someone starts challenging it.
And that's in addition to just having a video of this is who I want to leave everything to?
Yeah. So in Ontario, those videos are not valid. They're like dying wishes, but they don't have legal standing. Okay. So it has to follow certain protocols. Yeah. We haven't talked about people who are, especially for newcomers coming over. I think you touched on this, Pat. They may already have assets in other countries. So you have to also account for certain countries do not recognize wills made in Ontario.
Oh,
They do not recognize orders made in Ontario. Or if you're from certain jurisdictions, if people find out you died, there might be a new deed with someone else's name on it, but by the time your estate trustee can get over there. So you have to do a different type of estate planning. If you know you're coming down to the end, you may want to, transfer the property to the person you want while you're still alive. You might want to give them or a local will in that jurisdiction, reference that this is going to be a subsidiary will to the master will, which is here. People, a lot of snowbirds have properties in the States, Arizona, Florida being it. So where's your primary person? Your primary will is going to be where your primary residence usually, and you pay taxes and report yourself as primary. And then, different jurisdictions may require you to probate in their jurisdiction as well to recognize a certificate of estate trustee from an Ontario court. So
okay.
there's estate law requirements in other countries or other states and provinces. There's different capital gains issues, especially in the States. It is a wealth tax. So you have to really look into that. So we may have to, while we're planning for all your assets here with all the professionals, we may have to get a local person there to get legal advice or an opinion at least on, hey, what's the state of the law there when it comes to these things? What was the process?
Oh my. So in that case, and I can't say it, but I would almost want to gift that prior, because I certainly wouldn't want to deal with US or other jurisdictions at that time when stress is already really high.
So when I talk about, let's say, an 18 to 24 month process, if you have property in the States, you're extending the Canadian window by another year and a half, because you had to resolve everything in the States. You had to start everything in the States, resolve everything, liquidate, pay the taxes, bring it back into Ontario, and then you continue with Ontario stuff. And you have money for the legal expenses and all this lined up.
Another reason just to rent in Florida, right? Instead of
and also there's terminal taxes, right? Like, let's say you're in a lower income bracket right now, and you're in Ontario, and you die in Ontario. When you die, what we have is what's called a terminal tax rate. So your tax rate automatically booms up to 42%, regardless of what your income is. So even if you're paying no taxes right now, or you're making under 50,000 or 60,000, you're on a lower tax bracket. When you die, that's 42%. So all your taxes and your income taxes are calculated on 42%. So your capital gain is going to be 50% of 42, which is at 21%. So you'll lose basically a quarter of every dollar you have in an investment property.
Oh my.
Just on capital gain. Then you still have probate taxes and land transfer taxes to compete with.
So, I mean, the advice I just heard there was you should always have at least one term insurance policy just to cover all the taxes and costs.
That's the cheapest way to do it. That's the cheapest way to do it. You can't be having uninvested funds just sitting there for the rainy day when you could get access to funds within 30 days on a term policy.
Yeah. Well, we don't have any other questions in. We'll give it one more minute for people to send in questions. This was certainly helpful for me. I'm going to be doing a few things over the next few weeks. So thank you for that.
No problem.
So thank you again. This has been incredibly informative. And as a reminder, this is going to be posted on the website soon for future reference, and/or I will be sending it off to family members as a reminder of what's going on. So please join us in 2 weeks, where we're going to have our next session, and it's going to be on insurance. So I'm going to continue this discussion on term insurance and what's the most important thing, because we'll demystify insurance for you, all the different kinds and what you should have and approximate costs.
All right. So lastly from me,
yes, absolutely.
We're from Ramachandran Law Professional Corporation. We're in the eastern part of Toronto. So our firm's motto is, we're not just lawyers, we're people also. And you can see that on our website. But what we really try to do is, with anyone, we want to walk the circle of life with you. So as you can see, for newcomers, from immigrating here to buying real estate, having family issues, to having business or corporate issues, to potentially never needing us for civil litigation, and then to do the estate planning and do your final will estate work. We'll walk the entire circle of life with you, and we'll guide you, because the relationship we want, the clients we want, is not for a one-off or a one transaction. That we will walk with you throughout your journey, and we'll grow with you. So, if you ever need us, please feel free to reach out to us on any of our social media or phone numbers or anywhere.
No, that's great. And I think that makes sense too, because as you have a change in your family, you only have to go to one place and you would be able to give the advice on what has to be updated, given that change in the family history.
Yep.
So that's great. Thank you so much. This has been incredibly informative. Selfishly, I've enjoyed this. And thank you, everybody else, and we will see you in 2 weeks.
Thank you, everyone.